Welcome to the Voice of Retail. I'm your host, Michael LeBlanc. This podcast is brought to you in conjunction with Retail Council of Canada. The COVID era has brought with it not only questions around consumer behavioral changes and retail strategy deep dives, but it also raised many new questions around labor practices and labor law. Can I mandate COVID testing in the workplace? What must I accommodate? Can I field a mandatory employee survey? And the big one, can I require vaccines in my business? Joseph Cohen-Lyons is a lawyer in the Employment and Labor Law Group with Norton Rose Fulbright, a global law firm with more than 3,700 lawyers and other legal staff based in Europe, the United States, Canada, Latin America, Asia, Australia, the Middle East, and Africa. In this exclusive interview, Joseph and I discuss the state of labor law in the COVID era and try to answer the tough questions you all have regarding labor law at an unprecedented time.
And essentially what the Human Rights Commission said was that a personal objection to vaccines, however strong it may be, is not a religious belief, essentially, to put it in simple terms.
Right. Notwithstanding the fervor that some anti-vaxxers have, which is near religious experiences. Let's listen in now. Joseph, welcome to the Voice of Retail podcast. How are you doing this morning?
Good, Michael. Thanks for having me. How are you?
I'm well, thanks. Thanks so much for joining me. You and I met virtually, so to speak, on a Retail Council of Canada live stream, the Wednesday night live stream, and your topic was so interesting and is so interesting, and you have such a depth of experience. I'm thrilled you agreed to join me here on the podcast. So again, welcome.
Well, very happy to be here, Michael. Thanks.
All right, well, let's jump right in. Tell us about yourself, what your background is, what's your area of practice, and the firm that you work for.
All right, so I am a management side labor and employment lawyer. Essentially what that means is I represent companies of all sizes, really, with anything that has to do with the workplace. So anything that involves the employment relationship or the management of employees. That's something that I would help a company or an employer navigate. I'm currently working I work at a firm called Norton Rose Fulbright Canada. It's a large full-service firm. I'm in the Toronto office. We have offices all over Canada, and really Norton Rose Fulbright has offices across the world. I'm in their labor and employment group in the Toronto office. Prior to joining Norton Rose, I actually was in-house at a large automotive manufacturer where I was their in-house labor and employment counsel and did help them navigate partially through this the pandemic. So I have some experience in terms of what we'll be talking about today from the in-house role. And then prior to going in-house, I was at another large labor and employment firm for about 8 years. So I've been doing this for all told about 11 or 12 years, and always exclusively management side labor and employment law.
Now, how did you come to that? Were you, when you were a kid in the sandbox, were you adjudicating in the sandbox on behalf of, tell me about you. Tell me about
believe
your focus.
It or not, like everyone else, I didn't grow up wanting to be a lawyer. I wanted to be a hockey player or a fireman or something a bit more normal. But yeah, I mean, I think I was growing up, going to high school, and then into university, I became a bit more realistic with my expectations and my sights. And I was always interested in law, politics, humanities, and stuff like that. So law school was a natural choice. In terms of getting into labor and employment law, like I can't say again that I was born wanting to practice labor and employment law, but I fell into it because I went to law school knowing that I sort of wanted to be up on my feet and arguing cases and stuff like that, not just sort of in an office looking at contracts, although I do quite a bit of that as well as being up on my feet. But so I spent some time, I actually went to Queen's University in Ontario, and I did some work in the penitentiaries there where I was representing federal inmates and doing quasi-criminal law. And it just wasn't for me. I just didn't like the subject matter. So I had to think of some area where I could practice my advocacy skills, so getting up on my feet, but that wasn't criminal law, and I knew I didn't want to do family law, so labor and employment law is sort of a natural choice for someone that wants to do that, and yeah, so that's how I fell into it.
Whether you fell into it or certainly by intent of focus, it's an interesting place to be right now in the legal profession, and I guess many firms would have kind of plans around edge case events like pandemics, but really not. I mean,
right.
We can imagine certain scenarios. Certainly if we're here in Ontario, We've had some brushes with pandemics, but nothing like this. By the way, when you speak, do you represent in the province of Ontario or across Canada? What do you have any parameters around that, or is this Canada wide? Are you more familiar with one than
I'm
the other?
certainly more familiar with Ontario. I practice in Ontario. I'm licensed to practice only in Ontario. In Canada, what that means is that I can give legal advice on legal issues in other provinces other than Quebec. So I'm not ethically or legally able to give legal advice on things that happen in Quebec. But with respect to the other provinces, yes. And I certainly have, given the national nature of our practice at Norton Rose, I certainly have quite a bit of experience advising on issues in other provinces, and also with respect to these rapidly changing COVID issues.
And how much does it matter from a regulatory perspective or from the work you do, the province that you're in? I know there's certainly differences, of course, Quebec, but is it kind of like a tier one, a lot of the same principles, but when you get down to a certain level, then it varies based on the province and their various regulations? Like how granular, is that a good assessment?
That is a good assessment. So a lot of the general principles, certainly amongst the common law provinces, so those are every province other than Quebec, are very similar across the board. But the devil's in the details, and there definitely are some different regulatory issues that differ from province to province, and some of which I think we maybe will talk a bit about today when it comes to vaccines. And some of the sort of nuts and bolts rules with respect to COVID protocols would differ from province to province, like the fine details, but the general principles of employment law are pretty similar across the board.
Right. So, all right. So we're 18 months now into the COVID era, and I can think of different phases from your perspective as we all tried to figure this out. Can people go home, and do I have to lay them off? Are they laid off? Is that constructive dismissal if you're working from home? If people are working from home and they trip over their cat, is that a problem? When they were working for me. Tell me let's start this journey. Tell me the kind of the top, 3 or 5 issues that have come up as part of the COVID era in labor law. And I guess where I'm pointed with this, we'll talk, time is of the essence. We're now into this mandatory vaccination questions. We're into vaccine passports. But take me back a little bit in terms of how it's evolved, the different types of questions and different type of issues that you've looked at over the past 18 months.
Right. So, I mean, you're totally right. It's certainly evolved over the last 18 months, and I can't believe it's been 18 months, but here we are. And yeah, you're right. At the very beginning, it was the questions we were fielding were more around the lines of, okay, we literally have to shut down our business. We can't let employees in, or things have ground to a halt. What do we do with our employees? Can we lay them off? If we do, is it constructive dismissal? This always has been an area of law where the general principles of the common law or of the law were not, I would say, aren't particularly well understood by your average citizen or business owner, and a quick Google search could sort of send you down the wrong road. So it's easy to think, because a lot of the employment standards legislation in the various provinces allow or have this concept called a temporary layoff. And a lot of employers, when this all started, were surprised to hear that even though there is that concept in these employment standards legislation, a temporary layoff can still amount to a termination, and really it's under the principle of constructive dismissal. So we were delivering a lot of unwelcome news, I think, to employers who were finding out that, look, there is a risk when you're laying off employees. Now, it was a difficult time, and it remains a difficult time, because admittedly the principles that I'm talking about the general principles of employment law and with respect to constructive dismissals and layoffs were just not designed to deal with a situation like what happened with COVID, where all of a sudden you actually had about 80% of people. I mean, I don't know if you remember those days I do. March of 2020 or April, but the streets were empty, nobody was going to work, and so we were faced with the position where it was, okay, are 80% of the people in the province or the country
just been constructively dismissed?
Have they been terminated, and do they all have rights to severance? So
Right.
we were working through those issues, and we continue to, because there's, still some impact on that, and there's various statutory schemes in the various provinces that have been introduced to address that, and the relationship between those and the common law that I was just talking about is not particularly clear. So I think that'll continue to be an issue.
Now, one thing, if I could, we've mentioned it. You and I have mentioned it a couple of times, constructive dismissal. But let's not assume everyone understands. Explain for the listeners constructive dismissal at a high level, just so we make sure everybody knows what we're talking about.
Okay, so constructive dismissal is this principle that, to back up, generally speaking, an employer has the right to set the terms and conditions of employment for their employees. But there's a principle that if an employer makes a unilateral change to those terms and conditions that are so significant, or that is so significant, that it amounts to essentially a repudiation of the employment agreement, then a court will treat that as a termination. So essentially the same thing as if they had gone and terminated the employment relationship. And in that context, an employee would, and there's some nuances here, but generally be able to sue and would be entitled to the same damages he or she would have been entitled to had he or she been terminated without cause.
Right. And that order of magnitude of change that's developed less by regulation and more by case law. Is that a fair assessment?
Right. It's developed, I would say, entirely by case law. So usually, we often see this in the context of salary reduction or a change of duties, and there's some general principles, but generally speaking, it has to be a pretty significant change to amount to a constructive dismissal. But there's a line of case law, and I think important for our purposes, there's a line of case law that says, well, it's an implied right or it's an implied term of an employment agreement that an employer will provide work for the employee to do, and that the employer will pay the employee for the work that they do. So temporarily laying someone off is a breach of that implied term and is found to be a fundamental breach. And so essentially, absent a clear contractual provision allowing a temporary layoff can be the same thing as terminating someone. So essentially, and this is an area that is often misunderstood because, again, there's these employment standards legislation that talks about temporary layoffs, but unless you have a contractual provision that allows you to do it, it doesn't matter what the employment standards legislation says, it can amount to a constructive dismissal. That's why at the beginning of the pandemic and throughout, when companies were laying people off, we cautioned them about the risk that the layoff could be considered a constructive dismissal, and it would be in effect the same thing as terminating the individual.
And I guess that's where this concept of furlough came up, furloughing employees, or am I just playing with words? Is it one and the same?
It's one and the same. I think a furlough is a common term used, usually more commonly, I think, in the U.S., but in Canada as well, that essentially means a temporary layoff.
Right. It's a nicer word, I guess. It felt better.
Yeah. A little bit.
But from your perspective, from the court's perspective, they're indistinguishable.
That's correct, yeah.
Okay. All right. So we've got, at the beginning of the pandemic, we had a lot of layoff, some confusions about layoff. We had this big context of the world kind of in an apocalyptic state. What came next? Bringing people back? What was the next thing?
I think it's always been, because there's always been, and I think your listeners will appreciate this, even though a lot of people began working from home, there's many industries that stayed in the physical workplace. I mean, you have manufacturing, warehouse facilities, a lot of retail operations. So the question was, and continues to be, health and safety. So what protocols do we need to have in place to best prevent the spread of COVID-19 in the workplace and protect the workers? What can we ask employees to do? And this goes on to the vaccine issue, which I'll talk about separately. But what can we ask employees to do? What do we need to ask employees to do? And what are sort of our risks and obligations from the health and safety perspective? And it's funny, I I'm a lawyer, but all of a sudden, and I think a lot of people are finding this, but I tried to become an expert in virology and how does this thing spread and what's going to be effective and what's not, and certainly not what I was expecting when I went to law school. But
I know more than I ever really wanted to know about all this stuff.
Right, exactly.
And let's talk for a minute about obligations. So, employers have a broad-based obligation to provide a safe workplace, and there's a lot of different dimensions to that. And they also have an obligation to provide accommodations for people who, one way, shape, or another, can't fit or can't adjust to that. So speak to I guess that was, what does a safe workplace look like? And is that evolving? And then what does an accommodation look like? Because I guess this all kind of ladders up to what retailers ask me all the time. And they're asking, I'm sure asking you and your industry is like, okay, we'll get to it. But, everything from testing to vaccinations and mandatory vaccines. But let's start at this safe workplace and this accommodation concepts.
Right. So you're right. There's, in most provinces, there's a general duty on employers to provide, to take reasonable steps to provide healthy and safe workplace for their workers. So the obligations on employers with respect to COVID and these protocols really arise under this general duty. There's not, and there are specific requirements that I'm sure your listeners are familiar with that have evolved throughout the pandemic, but the bulk of it really is under this general duty clause. So, really it is a bit of a moving target, and it's about following the guidelines and recommendations that really have been published throughout by the various provincial Ministry of Labor, Ministry of Health organizations. That
occupancy, space, distance, plexiglass. Good to be a plexiglass salesman in 2020, right?
Right, exactly. So there are some pretty good guidelines out there, and I think from an employer's perspective, the best thing to do is familiarize yourself with those guidelines and implement them in your workplace to the extent that it's reasonable. Now, that being said, there have been and continue to be specific regulations. So, for instance, in Ontario, there was for a period of time a requirement that if someone could work from home, they had to work from home. So that was not just a general duty. Okay, what do we need to do to provide for health and safety workplace? That was a specific requirement. So those do exist, and again, they change sometimes from day to day and minute to minute. But there are some specific requirements that need to be met with respect to also social distancing and occupancy rates as well. With respect to the duty to accommodate, this is a duty that exists for employers and businesses independent of the pandemic. But I think it certainly come up in the context of the pandemic in terms of, for instance, if there's a requirement to wear masks in the workplace and somebody can't medically tolerate that mask, what do you need to do to provide an appropriate accommodation for that person? Right. The same thing, and I think we'll probably want to talk about this in a separate topic, but certainly with respect to vaccines, there's been a lot of talk about the right to be accommodated with respect to mandatory vaccines and whether there's a duty to do that. I think we could talk about that separately when we talk about vaccines, but you're right. An employer in implementing whatever health and safety measures are most effective does have to take into account the rights of employees with respect to the duty to accommodate. But it's important to note that there's not a freestanding right of individuals and people to just be accommodated for their preferences and likes and dislikes. The duty to accommodate is only triggered where some human rights ground is engaged. So you only have a duty to accommodate someone's need arising from a legitimate human rights ground. So I think most commonly it would be a disability. So someone suffers from some disability that doesn't allow them to engage in a certain practice or to do something, and what do you need to do to accommodate that? But someone just saying, I don't like masks is not likely to trigger a duty to accommodate.
Well, this has been a build-up to the questions that we're getting today, so let's get there. So it feels like we should talk about this into kind of two things. One is mandating things like testing, and retailers, because we're speaking to the retailer audience, and of course they have three constituencies. We have head office staff, we have frontline staff, and then we have warehouse staff. Just to speak broadly about three, so I like things in threes. But putting even that aside. So I would like to make sure, let's imagine our world where the vaccines are not widely distributed and then we get to where they are.
Right.
I'd like everyone to be tested before they go to work. Is that an okay ask on behalf of, can they say, listen, you can't go work in that warehouse. You can't go into my store unless you're tested. Is that a reasonable thing? What's been your experience and where are we landing on that one?
Yeah, I think the answer to that is broadly yes. I think people were a bit more concerned at the beginning of the pandemic, but now it's, I think, relatively safe to say that an employer can, and in many cases should, implement a mandatory testing policy. But again, I think that would need to be subject to the duty to accommodate. And I think with respect to testing, there might be some legitimate medical reasons why someone couldn't engage in testing, or you might need to provide some accommodation in terms of the manner in which testing is done. But generally speaking, I think you can implement that policy, and a lot of employers have.
Now, where does this, if at all, intersect with the privacy around health information? Obviously, I guess it supersedes it or doesn't touch it. I now know something about you now that you've taken this test. How does that...
Right, it does. You're right. It does intersect with it quite a bit. And I think as a general principle, employers, businesses, whomever is collecting this information is best suited to treat it with the respect it deserves. So, take care to ensure that you only gather as much information as you need, that it's kept in a secure way and the like. But surprisingly enough, in many jurisdictions in Canada, there is no legislation that governs the collection of this type of information. And this is something that I think the common public is a bit surprised by. So in Ontario, for instance, there's no private sector privacy legislation. So there's no legislation that really governs an employer gathering information, personal information, including healthcare information, except in limited instances, but from their employees. Now, that being said, there's some common law duties that you need to consider, and then there's just the general best practice employee relations issues that you want to consider. But that's different. And there are provinces in Canada, and just off the top of my head, Alberta, British Columbia, and Quebec, which again, I can't speak too much about Quebec, but those provinces do have specific privacy legislation. So certainly you need to ensure that whatever information you're collecting, whether it's about testing or vaccines, as I'm sure we'll talk about, is kept in accordance with those statutory requirements.
Okay, the next level. I want to ask everyone if they've been vaccinated or not. Can retailers do that? A mandatory survey, you must fill it out. Your thoughts on that?
Right. The answer is probably yes. I guess the question is, who are they asking? If it's their employees, the answer is probably yes. And I think a lot of retailers and other businesses are routinely asking about vaccination status. I think people were a bit hesitant. If you talked to me about a month ago, I would say it wasn't quite as common. And I think now it's pretty common. The answer is yes. You can. I think there different considerations would apply if they're asking the public for that information to come into an establishment. And of course, we know in Ontario, at least just yesterday, we had the first day of this vaccine passport. So in certain cases, a business, maybe not.
Fortunately, not retail, not
yet. But some businesses are required to ask about this information. That may evolve over time. So I do think that it's permissible. And another point, I think, for your listeners, the Ontario Human Rights Commission actually just published a report yesterday, coincident with the vaccine passport coming out in Ontario, that essentially endorsed the practice of asking about vaccination status and mandating vaccines in appropriate circumstances, and essentially said that as long as it is done in compliance with applicable human rights considerations, which namely the duty to accommodate a disability, which is a little bit more narrow than people may think, then it's permissible. So
to be clear on that, the fact that I just don't want to do it does not bring rise to an accommodation just because I don't want to do something. There's got to be more meat to that bone, so to speak.
Well, that's right. So in this publication from the Ontario Human Rights Commission, which I stress is not law, it's a government body that expresses their view of the law, and I'm sure there will
opinion.
be.
It's not law.
It's an opinion, but it's
carries weight.
It tends to carry a bit of weight, and I think it's a good signal of where the issue may go. They specifically address this issue of not, just a personal decision not to be vaccinated, or even a personal belief that, I think that people have some strong beliefs about the vaccine. And essentially they said that those are not protected by the human rights legislation in Ontario. So, and basically what they're saying is that it's not. So the Human Rights Code in Ontario protects you on the basis of religion, or what they call creed. And essentially what the Human Rights Commission said was that a personal objection to vaccines, however strong it may be, is not a religious belief, essentially, to put it in simple terms.
Right. Notwithstanding the fervor that some anti-vaxxers have, which is near religious experiences.
Right.
All right,
now,
so let's get...
That being said, before we go on, I do anticipate someone trying to challenge that and trying to link, and I've just in my own review of the stuff that's being out there, I do anticipate someone trying to say that they have a reasonably held and honestly held religious belief that they can't be vaccinated, and to link it to a real existing religion. So I think we'll see that.
There's some precedent for that in blood transfusions and other things, right?
Right.
Yeah, that's not unheard of. Okay, so the question that many retailers are asking me, and now when I speak of retailers, of course, it's not one large homogeneous group. We have pharmacies or we have lumber retailers. So I want to, as a retailer, and let's say I'm not a pharmacy retailer, I want to mandate anyone who works in my store or my warehouse or in the head office needs to be vaccinated, or you can't come to work. What kind of ground are people on?
Right. So the general consensus is, and I think there's some differing views, but essentially that an employer can mandate vaccines for employees to come to work, to report to the work. They can. Yes. So as I said, it's mandating and this goes to what the Human Rights Commission has said, but requiring
that's
a vaccine.
New. I'm surprised at your answer a little bit, because it's not what I thought your answer would be. I thought your answer would be, no, you can't mandate someone get vaccinated. You have to accommodate it.
But you accommodate what? So you do have to accommodate someone if they're unable to be vaccinated because of a legitimate medical
allergic
exemption. You're allergic to the vaccine. There's I think it's myocarditis. Like you experience that on your first vaccine. So there are legitimate exemptions, but just requiring someone to be there's no cause of action for requiring someone to be vaccinated. I mean, they don't have to be vaccinated. And it's not like you're forcing them to be. If they don't want to, then they don't have to come to work, or they don't have to work for you. But I don't think
that doesn't trigger constructive dismissal.
Well, this is where I think the cases are going to come out. So I do think that an employer can say, we require you to be vaccinated to come into work. I don't think that saying that in and of itself will give rise to an ability for an employee to sue and say, you made me get vaccinated, I'm suing you. But the real question is going to be, what if someone, and I think we'll see cases on this for sure, but what if someone says no? Right. Generally speaking, I think in most circumstances, you probably will have to find an alternative or terminate them without cause. So pay them some form of severance pay, whatever they may be entitled to under either their contract or at common law. That could be a whole other topic. But I don't think that. So I think that you could terminate them without cause. in certain circumstances and in certain contexts, it may be grounds to terminate with cause, but I think that would be a factually specific inquiry, and each case would differ. But in healthcare settings or the types of environments,
I see.
You can think it might be cause to terminate.
So there's an option to say, and I'll just play this tape back so we can be clear for the audience that I want to mandate anyone who works for me, comes into the store, warehouse, or head office. If you're going to come to work, you need to be vaccinated. And if you work in and if you can't find an accommodation, you can't do your job if you're a clerk from home. I'm going to terminate you without cause, basically.
Right.
Maybe I'm a pharmacy, and maybe maybe there's a with cause there, but that's where it sits today. But there, of course, there's the risk that someone is going to start taking that to court and testing that principle, right? I mean, this is the way the system works, I guess, at this point.
Absolutely. Right? And for what it's worth, I think that employers are going to test it as well and try to terminate for cause. And I think we're going to see whether a refusal to be vaccinated, which really, if you think about it, is no different than a refusal. I mean, you could say it's a refusal to obey a workplace rule. It's like, what if someone refuses to wear a hard hat at a construction site? You probably could terminate them for cause. So I think that there's going to be litigation about this, and where it lands, we'll see. This is certainly an uncharted territory, and it's unprecedented. So there are no clear answers to this. There's only our best guesses based on the general principles of employment law and past cases, right? And because we haven't dealt with the global pandemic and anything even that close to these mandatory vaccinations, although there are some cases about flu vaccines in the healthcare settings that are not particularly helpful for the current situation we're in. But, this is all to be decided.
Interesting. So I guess as it always, I shouldn't say as it always, but it often comes down to your tolerance for risk as managers.
Absolutely.
Right. I mean, particularly in this case, because there's no black letter law on this. There's no case law. So it's about to be, it's about to be developed as time goes past. So last question for you. You've been very generous with your time. And thank you. And again, for anyone listening, I'm sure you would join me in saying, listen, make sure and you're in different provinces. These things are complex. Make sure and measure twice, cut once. Perhaps check with your own lawyer. And that gets me, gets me to my last question: is if they want to follow up with this with you, your firm, and perhaps they don't have a counsel that has this level of expertise, how would they get in touch with you?
Well, they can email me, call me, look me up online. It's Joseph Cohen-Lyons. I'm at Norton Rose Fulbright, Canada. So I think it's fairly easily accessible. And I think if you go on our firm's website, there are some great resources about return to work, COVID, employment law in the COVID era, and other business issues in the COVID era. So there's great resources on our firm site. I thank you, Michael, because I should give the disclaimer that nothing I said today obviously constitutes any legal advice. Everything depends on the facts of the individual facts of a case. And when you're talking about these particular issues, the law is not particularly clear. So you're right. It's about your tolerance for risk. And I would encourage anyone listening that has any questions to either reach out to me or their regular employment lawyer for guidance.
And you would have, if they reached out to you and perhaps they had businesses, as many of our retailers do in Quebec, you would have resource you could point them to within your firm to address that as well, right? Right.
So we have a large office in Montreal. I think our firm actually, we have a very large office in Montreal and in Quebec, so plenty of very competent colleagues out there.
Right on. So one call to you, and you may say, listen, that's not. I have less expertise in this part of the country, but here's my colleague who has tremendous depth of expertise. So it's a really one call, and I'll put all these links, your email address and the link to the firm in the show notes, just in case they can't find it. But Google, I'm sure, is your friend, and when it comes down to
exactly.
Listen, this has been so generous. It's so topical. Questions asked every day. I know many retailers were looking forward to this podcast, and I hope they've started to answer the questions, and you've provided some guidance. But again, thanks again for joining me on The Voice of Retail. It was wonderful to chat with you at further length, and maybe I'll get you back later in the year or early next year and see how these things are evolving and what's next, because there's going to be a next.
That's right, Michael.
So let's if you're open to it, let's get you back on later and see how these things are evolving.
Yeah, that would be great. Thanks for having me.
Thanks for tuning in to today's episode of The Voice of Retail. Be sure and follow the podcast on Apple, Spotify, or wherever you enjoy podcasts so you don't miss out on the latest episodes, industry news, and insights. If you enjoyed this episode, please consider leaving a rating review, as it really helps us grow so that we continue to get amazing guests onto the show. I'm your host, Michael LeBlanc, president of Emmy LeBlanc Company, Inc., and if you're looking for more content or want to chat, follow me on LinkedIn or visit my website at emmyleblanc.co. Until next time, stay safe, have a great week.